Today's question has to do with multiple issues involving estate planning and I believe also touching on Medicaid planning. Bear with me while I read the question in full because it has many parts. Can I be held responsible for my father's medical bills and nursing home bills in the state of Wisconsin? That's the big question. Then the reader writes, my father recently entered a nursing home. I have power of attorney. So he's saying he's the agent under the power of attorney, I believe. And I'm also listed as a co-owner on his checking account. I've been paying his bills since he entered the nursing home from this checking account. This includes bills for his home, which he owns. We wrote a will ourselves and filled out paperwork naming me as his power of attorney and notarized both documents. We also filed a transfer of deed for the house, listing the reader's name and my sister's. I am wondering if there is any way I will be held responsible if any debts that exceed the value of his estate, especially if I need to sign for him if he is admitted for medical care and unable to sign for himself. So listeners, as you can see, there's a lot of issues going on here. Sounds like they created a will themselves, filled it out. They also did a deed transferring the father's house from the father to his children. And then the father was admitted to nursing home. So I don't know all the facts of this situation, but I attempted to answer the question as much as I can. This gets into complicated areas of Medicaid planning. But in short, to the reader, if your father validly named you as agent under his power of attorney, you can pay his bills for him under that POA document. It also sounds like you're named on the checking account, so he gave you authority to pay his bills. Your question about being a co-owner of the checking account and transferring the home to you and your sisters gets into what I am guessing is a question about divestment of assets. Now for Medicaid, there's a 5-year look-back rule for gifts made to anyone. Transfers for less than fair market value. Sounds like putting your name on the checking account and then transferring the deed to the house to you and your sisters was a gift. That's what Medicaid would look at as a divestment. Medicaid is the program that will pay for long-term care, nursing home care for people who are impoverished and don't have enough money to pay for it themselves. So your father can gift the home to you and these checking account assets as long as he has enough other money to pay for his nursing home care for at least 5 years. If he does not, then you should be aware of this 5-year look-back period by Medicaid. If your father goes into the nursing home and needs state of Wisconsin assistance through the Medicaid program, then they will look back at these transfers made to you and your sisters, and it's possible they would deny your father Medicaid assistance for making these divestments. Now, the other thing I wanted to briefly mention is you said you had the will notarized. A will always needs 2 witnesses, so make sure it was witnessed by 2 people not related by blood or marriage. In the notary, in addition to that, is fine, but a notary alone is not enough. The power of attorney can be signed in front of a notary. I recommend you check all these documents and discuss this situation holistically with a Medicaid and estate planning attorney. There are many issues going on here and it's more complex than I can answer in this brief video, but those are the things I would look at. And in general, keep in mind that 5-year Medicaid divestment look-back period. Great question and thank you for asking.